Do we already have a law on the books that makes it illegal to interfere with police activity?
We do, yes, sir.
So why do we need this bill on top of that, this new law?
Does this apply just to public spaces, or does this apply to private property as well?
I don't have that answer, sir.
And which one of the officers is going to be the 25 feet? Is it going to be him over there,
It doesn't
him over
really
there?
matter. Whoever one asks you, just follow his instructions. Real simple.
So,
Real simple.
so that means it could be longer than 25 feet from the actual person.
Maybe.
Rep. Fontenot, if we operated all these years without this requirement, why do we need this now?
You don't think we ought to have an exception for private property?
I do not.
So I'm just wondering, is this law even constitutional? Have you researched that?
Mr. Speaker, real quick, there's a clear difference between Judge Carter and I. He sits on the bench and judges police officers, and I was the police officer in the trenches making that decision.
Greetings, everyone, and welcome back to another video. A federal judge has blocked a Louisiana state law that was passed last year that made it a crime for anyone to approach a police officer within 25 feet while they were in the performance of their duties. Now, 10 years ago and 2 years before Turn of Your Driver, which covers Texas, Louisiana, and Mississippi, Texas tried to pass a similar law that made it a crime for anyone to film police officers within 25 feet. So former Dallas House Representative Jason Villalobos introduced House Bill 2918, which would make it a misdemeanor to photograph police within 25 feet, raising serious concerns that the bill, if passed, would violate the First Amendment and prevent individuals from holding police accountable. And if you're a Texan carrying a firearm, that buffer zone will go from 25 to 100 feet. Villalobos reportedly said police approached him about creating the legislation, which would apply to everyone, including journalists. Villalobos has since said he revised the bill, changing the buffer zone from 25 to 15 feet.
So hypothetically, if I were photographing or filming with a tripod and an officer starts to approach me, does the 15-foot halo move with him, and am I therefore breaking a law?
Now you're getting some complicated logistical questions. So the way we've drafted the new version of the law, it says that if you are there's a vote going on, give me 1 second.
Sure.
If you're the person of focus being engaged, right, then you're exempt. So if somebody pulls you over in an automobile, if a police officer pulls you over, you would be exempt in that situation. If you're the person being arrested, you put your phone out, you're exempt in that situation. We're not trying to keep the individuals from being able to keep the officer accountable. It's those third-party outside agitators that we're most concerned about.
So if I have a camera on a drone and I were to fly it close within the 15-foot boundary,
I
is
see what
that
you're
allowed?
saying. If you had your own drone, I would imagine that would be prohibited, but again, the legislation doesn't contemplate that kind of technology. Most of these individuals who are doing this are not using that kind of technology. They're actually getting in the face of the officers and disrupting.
The Texas House bill received a lot of backlash and criticism from lawmakers, lawyers, and even civil rights advocates, and the bill was thrown out. Eventually, 2 years later, Turn of Your Driver became the law of the land, which covers Texas, Louisiana, and Mississippi, and it established that you have the right to record police officers in the performance of their duties. However, there was just one problem. Even though you have the right to record the police, and police officers can no longer claim ignorance of the law or qualified immunity, that very right is not without restrictions. Reasonable restrictions such as time, place, and manner must be narrowly tailored to achieve a fundamental government purpose, meaning they must address a specific concern and not be overly broad. Now, fast forward 6 years later, and now Louisiana is passing a House bill very similar to Texas, except for instead of recording within 25 or 15 feet, you just can't approach an officer within 25 feet. So all they did was just remove the recording provision out of the bill. The bill passed the House and the Senate before it was vetoed by former Governor Edwards. Here's the veto message from former Governor Edwards stating that House Bill 85 is unnecessary because Louisiana already has a law that makes it a crime for interfering with a law enforcement investigation, which carries a penalty of 6 months in jail and a $500 fine. Further and perhaps unintentional, the effect of this bill, were it to become law, would be to chill exercise of First Amendment rights and prevent bystanders from observing and recording police action. Each of us has a constitutional right to freely observe public servants as they function in public within the course and scope of their official duties. Observations of law enforcement, whether by witness to an incident with officers, individuals interacting with officers, or members of the press, are invaluable in promoting transparency. Therefore, House Bill 85 is not needed and will not become law. The very next year, Governor Edwards loses re-election to Jeff Landry, who used to be a former police officer, which is the final piece in order to make this bill pass.
In this state, and this was a bill that had been vetoed before. It is now going to be signed. So you want to tell us about it?
Yes, I think first and more importantly, that it's such an honor to serve next to a governor who once wore a badge, and the men and women behind us who are sworn to protect us. I think you see across America that violence on police officers continue to rise, and there was a delicate balance of finding a safe distance for police officers to be able to do their job, both for them and the person that they are affecting an arrest on. So certainly working with the governor's staff and himself and the law enforcement professionals, we think this is a good place to fall. This is a bill that's enacting all across America that gives our police officers a peace of mind and a safe distance to do their job.
Before this bill became law, Representative Brian Fountainu took questions from his constituents during a 50-minute hearing in which I decided to condense it down.
House Bill 173 by Representative Fontenot, offenses affecting law enforcement, create the crime of approaching law enforcement officer engaged in lawful enforcement duties, provide for affirmative defense penalties.
Remember, my bill creates a safe distance for people to be able to witness, videotape, and watch law enforcement officers in the scope of their duty, and it creates a distance of 25 feet after being asked by a law enforcement professional, which is a safe distance. It also creates the punishment and a fine of up to 60 days in the parish jail.
Do we already have a law on the books that makes it illegal to interfere with police activity?
We do, yes, sir.
So why do we need this bill on top of that, this new law?
Well, not necessarily. Someone within 25 feet could be interfering with the duties of a police officer. I think we've tested over and over again the safe distance for which an officer has time to react to a perpetrator who may be violent. So this person may not be choosing to be interfering with the duties, but in their brain could be thinking to do something harmful to an officer. So we're creating the safe distance for that officer to be able to effectually make an arrest.
Representative Fontenot, I will tell you I do appreciate some of the amendments made as it relates to last year's bill, but I still have some concerns here. So I guess my question is sort of in line with Representative Willard. If I'm trying to video, do you think that 25 feet, and I'm not interfering with the officer's, effectuation of an arrest or anything like that, but I'm just actually trying to video to document the incident. Do you think 25 feet is close enough?
I do, and like I gave Rep. Jordan to Representative Willard, if I was standing at this podium and I was trying to make an arrest on a citizen, you could be 25 feet away, which is where Rep. Tarver's at or where Rep. Bacala's at, and still get that video and get what you want, which may be something that we think should be preserved.
Right. So who's going to determine what's 25 feet? Is an officer going to measure out?
Well, so I think an officer has the burden. Obviously, he has to put together a police report. He has to articulate to the prosecution what he thinks 25 feet is. I think if the officer doesn't take an accurate measurement, he doesn't ascertain pictures, he doesn't ascertain video, I think his ability to get a conviction is going to be hampered. So as you know, as an attorney, the burden is on the state to prove what's 25 feet, and that officer is going to have to do a very good job in articulating, one, I think, was he 25 feet? Was he more than 25 feet? And again,
look, I understand that when it gets to court. I guess the concern, one of the concerns that I have, though, is that that's not going to stop the officer from arresting this person, right?
Well, I think you're trying to make the interpretation that the officer may arrest if he's at 19 feet, and I would disagree with you. Officers have discretion, and I want you to know that in many times in the criminal law and the highway traffic regulatory law, we talk about following too close. You can't follow more than 400 feet. Can the officer write you a ticket if you had 320? Again, the burden's on the state to prove the guilt of the individual.
Well, I understand what you're saying is when we get to court and what the burden is, but practically speaking, I'm talking about on the scene. You're saying Tarver, where Tarver is the 25 feet. I may be where Representative Emerson is, and he doesn't like the fact that I'm filming, and he says, hey, look, you weren't far enough away, and so I'm going to arrest you. So now that person is arrested, may have to post a bond, what have you. Now, I know the burden of proof once he gets to court is that, but that person may sit in jail for 2 days or even overnight while he's waiting for a judge to bond him out. Do you think that's fair?
Well, I certainly do not think it's fair if the officer can prove that he was beyond 25 feet and still made an arrest. I certainly don't believe that's fair, Representative Jordan.
Does this apply just to public spaces, or does this apply to private property as well?
I don't have that answer, sir.
Well, so if you're on a public road and I'm in my yard and there's 10 feet between us, does the officer have a right to tell me to move back if I'm on my property?
I can't tell you what the jurisprudence is. My opinion
I
is,
can tell you what the jurisprudence is if you'd like to know.
I would think that if the officer feels that he's in danger, he's asked you to get back, I would think that he can. Again, I don't know what the jurisprudence is, but I go with, my son asked me, Dad, why'd you bring this bill? I said, how simple it is for you when the officer gets back to say, just get back. He said, that's a good point, Dad. I'm glad you brought the bill. So if I'm standing at 10 feet and I'm not at no harm to the officer who's standing at the edge of the road, I'm not sure what's the issue to back up 15 feet.
Well, but the issue might be that I want to document that and I'm on my private property and I have a right to be there and he's on a public space. So that really is the issue of what we have a right to do and what's constitutional. So I'm just wondering, is this law even constitutional? Have you researched that?
Well, I did notice that in the governor's veto message last year, he talked about it being unconstitutional, but I didn't see any jurisprudence to say it was unconstitutional. And you know, this body, as we pass laws, they are assumed to be constitutional until such time otherwise proven. I would say this, we added the amendment, as you first referenced, that the officer had to tell you to get back before you would be in violation. I think that clears up some of the ambiguity that may have been in last year's bill.
Well, look, I still think the fact that you don't address the private land versus public space may still make it unconstitutional, but I appreciate it. Thank you, Mr. Speaker.
Thank you, Rep. Jordan.
Rep. Fontenot, if we operated all these years without this requirement, why do we need this now?
Well, I think we could go back and look at thousands of police reports and see where we had instances where we wish we could have had them back 25 feet. You know, I said this in committee, Rep. Landry, and I think this is important. There are a lot of things transpiring, and the most intense time in a law enforcement professional's career is when he's got his hands on a perpetrator to effect an arrest.
Can you help me with when it's multiple officers? So it's multiple officers on the scene, and they're, as I said, in my parking lot about 4 days ago, there were multiple police officers from all kind of agencies on my parking lot. So where was the 25 feet for him to, if the law was to pass, I say to my legislative assistant, go outside and find out what's going on my parking lot. And which one of the officers is going to be the 25 feet? Is it going to be him over there,
It doesn't
him over
really
there?
matter. Whoever one asks you, just follow his instructions. Real simple. Real simple.
So that means it could be longer than 25 feet from the actual person.
Maybe. Maybe that's what he thinks is a safe zone. Maybe there's a bomb in the car in your parking lot and he's trying to make you back up. We're asking you to stand at a reasonable difference, Representative Marcel.
I'm not suggesting that you're not. I'm just telling you in real life circumstances, because it happened the other day at my office. And I'm trying to figure out for our citizens that not trying to cause the officers any harm, as my legislative assistant wasn't, just trying to find out what is going on my lot, right? I'm trying to figure out if when there are multiple officers, which one is going, if everybody says get back, then you may be 100 feet back. Because this officer's standing here and that officer's standing there. That's what I'm trying to figure out. Who's going to measure? Who's doing this measurement?
As I explained to Rep. Jordan, I believe that the burden is on the officer who would effect an arrest to prove.
But that's after that's after my assistant had been arrested and had to bond out. Is that right?
You didn't bring up that your assistant was arrested.
No, he wasn't. Okay. And he definitely wasn't. He's a minister. He was not arrested.
So he probably, when they said back up, he backed up?
He may have, but the question becomes, back up from which one of them? But I'm finished with my questions.
Brett
I
Bacala,
just don't think it was a good idea to bring it. I don't think it's necessary
I respect that.
to even pass it. Thank you.
So, Rev. Fontenot, if you said that it's not unconstitutional until the court says it's unconstitutional, the court just adjudicating it's unconstitutional. It's unconstitutional because the act was done. If I'm on my property, in my town, most of the residential houses are required to be 25 feet from the curb or the state or the city property line. So in that 25 feet, if I'm standing on my steps or I'm in my front yard, but most streets are 25 feet wide in my cities. The actual street is 25 feet wide. So I have to go in my house to be outside 25 feet. If the car is parked on my curb and I got a 25-foot right-of-way in front of my house, a 25-foot property line, you telling me my property, I got to go in my house, and the officer can make me go in my house, even though I'm not doing, I don't have a problem with officers not being interfered in their job. I'm for that. I don't want them to be interfered with. So if I'm on my private property, though, and you deny me access to my private property, that's unconstitutional. You ain't got to go to court. I mean, you got to go file suit on your bill in order to get it adjudicated, but it's clearly in violation of the use of my property. So unless I'm you creating a law to allow you to arrest me for standing in my front yard. That's exactly what this law does. It may not be intended to do that, but that's what it does. And especially in towns like my city, in my community where I live at, I don't have, we don't have 25 feet in front yard most of the time. So you don't think we ought to have an exception for private property?
I do not.
Okay, and also, we don't have a law requiring officers to maintain their body cam when they come in contact with the public. Do we have we had a bill one time to require the officer to activate his body cam and activate his automobile cam when he come in contact with the public, making an arrest or doing his official duties. That didn't pass. There was an attempt at one time to do that. So it was opposed by law enforcement. So would you support a law that requires when an officer has a situation where someone within 25 feet that he activate his body cam?
I do support body cameras, sir, and I support administrative codes and procedures that would do not put their camera on.
But the body cam would capture the situation. If you want to say you got to be 25 feet, that body cam would help you understand what that officer is dealing with and what the citizen is doing. So I think a body cam should be activated, and the officer should not have a choice in that. If he's going to charge somebody for being within 25 feet to be not doing anything, just in 25 feet is a violation of the law, which in itself makes it unconstitutional. But say if he wants to make sure officers are protected, he ought to have his body cam activated. You agree?
I agree.
Okay. Now, how many police officers in this state has been injured as a result of folks interfering with the performance of their duties in the past year?
I don't have that data, sir.
Well, I would think there is a database for police officers injured on the job. So I'm just curious. Nobody have that information? As how many officers have?
I don't have that information, Judge. I would say this. I would hope that this bill makes it zero once it.
Well, I think it's pretty.
passes.
I don't know if that's a high number of police officers being injured as a result of someone interfering with their job, because I would think most people, if an officer asks them to back off so I can do my work, they're going to back off. Now, those few that don't, they already violate, the law is already in place for the officer to take action against them. So you're making it 25 feet. And if you're investigating a rape case and someone's standing in hearing distance, this is the officer's discretion to take that person further away so people don't hear. If you don't want them to hear, officer will have discretion to conduct that interview in an area where that information is not going to be exposed. So, would you not do that as a police officer? You investigating a rape victim, or you have an information being made
if I take
public?
the scenario I'm
Judge Carter,
investigating in your community, probably not.
The member is out of time.
Is there any objection to give an additional 3 minutes? There is an objection. Those in favor of granting an additional 3 minutes, vote yea. Those opposed, vote nay. The clerk will open the machines. Willard, no. Boyer, no. Green, yes. The clerk will close. Willard, yea. Bagley, nay. The clerk will close the machine. We have 37 yeas and 56 nays, and the motion fails. We have no further questions. You have a right to close on the bill.
Thank you, Mr. Speaker. Members, oftentimes we get asked to do these
Hold
things.
on one second. Representative Wilford Carter, why did you rise?
Thank you, Mr. Speaker. I thought I had an amendment at this.
There's,
Well, point of order. If there's an amendment at this, would that extend the debate?
yes, I'm sorry, there is an amendment being, I was unaware that there was an amendment, so you are correct, yes. Members, we're going to have to hold 1 second. There's an amendment being prepared on the bill. Madam Clerk?
Mr. Speaker and members, Representative Wilford Carter offers up a one-page 7 minutes, 2236.
Rep. Wilford Carter on your amendment.
Thank you, Mr. Speaker. Members, I'm all for police officers being able to do their work without being interfered with. And that protects everybody. They're not interfered with. However, I do have a concern about officers not activating their body cam. That can resolve a lot of problems if they just activate their body cam. So, and this amendment just simply says, if the officer gonna warn you that you're in 25 feet, he should activate his body cam so that he can protect himself as well as the citizen, that he's 25 feet. That would be very helpful in that litigation. And also, if a person is on their private property and an officer comes on their private property away from the arrest or the incident or the investigation, that he cannot go on person's private property and tell them they got to go within 25 feet because they have to go in their house. So that's all this amendment does, those two things.
Any questions on the amendment? Is there any objections to the adoption of the amendment? Representative Fontenot?
So to the judge's point, I concur with him. He asked me, I said I concur. But we're talking about someone who's violating the law and someone who's violating departmental policy. I support that the officer, anytime, if he's at 2 feet, 50 feet, or 100 feet, and he has a body camera, he should activate, and the policy should talk about activating that body camera. As it pertains to private property, I think we're running up on the constitutional issues. Is a law enforcement lawfully there? Was he called 911? Is this going to be an affirmative defense for someone who, when an officer legally has grounds to be there and is conducting an investigation, is it giving them the right to get away from that? So for those reasons, I would object.
So I would ask that you support the amendment because it really doesn't take anything from the true value of the bill. All it does, if I'm on my private property, and my private property happens to be within 25 feet of the road, I certainly I'm going to retreat, and I should retreat, but not 25 feet because it's on my private property. I shouldn't be on the curb or I shouldn't be on the sidewalk, but if I'm on my private property, and I have to go in my house if it's within 25 feet. So there's no objection to the first part. It's the second part you have a problem with, and I think if you're on your private property, you ought to be okay. And there's no reason for the officer to come to your private property. Now, of course, if he's on your private property making an arrest, there's already a provision in the law to allow him to do that. This doesn't stop him from making an arrest if he's going to your house to arrest somebody at your house. Of course he can do that. That's already present law. That's present situation the officers have the authority to do that. But if he's doing a car stop or checking somebody's car in the street and I'm in my yard, I ought to be able to stand in my yard and watch what's going on.
Okay, I'm trying to make sense of the bill as well as the amendment.
I'm not here to speak for the bill.
Okay.
I'm just speaking for the amendment requiring the officer to turn on his body cam when he warned the citizens within 25 feet. That's all I'm trying to do with this amendment right now. This bill seeks to set up a distance requirement, which I don't think is right, and I think there might be some constitutional issues with this bill. This would help it some, though. It would help the citizens some.
So now, when that officer asks that citizen to move, who's responsible for making sure that it's 25 feet? Is it the officer, or is it the citizen, or is it both of them? Do they both stop and start measuring?
Well, the body cam would be helpful, but at some point, the state would have to prove, or the city would have to prove by beyond a reasonable doubt that citizen was in 25 feet. But now that's not going to help that citizen. That's not going to stop him being arrested. He's going to be arrested. He's going to be jailed. He may not be bound out of jail. He's going to lose his job. He's going to lose his house. There's a lot can happen. A person is incarcerated. In our world, in this state, oftentimes people are incarcerated until they plead guilty to something, whether they're guilty or not, because our bonds are generally too high. So I don't know what the bond would be in this case, but the judge would set the bond at. But if he couldn't bond out of jail, he would sit in jail till you go to trial.
Representative Wilford Carter has offered up an amendment. Is any objections to the adoption of it? Representative Fontenot?
Mr. Speaker, real quick, there's a clear difference between Judge Carter and I. He sits on the bench and judges police officers, and I was the police officer in the trenches making that decision. What he puts in here is he says the peace officer did not activate his body camera before issuing the lawful command. So what he wants an officer to do when he's involved in an altercation and trying to effect an arrest on the side of the road when someone's trying to ascertain his gun is to say, excuse me, sir, don't take my gun. Let me turn my body camera on so I can tell you to get back 25 feet. For those reasons, I would object to his amendment.
Rep. Carter, you have the right to close.
That is not what this amendment does, really. That's just a spin. So let's pass a law without a spin. What are we requiring in this amendment? If what the officer feels uncomfortable that this person within 25 feet, they may be interfering with his work, okay, and he's gonna, hey, look, you gotta get back some, turn your camera so everybody can see what's going on. Just turn on your camera. So a trial fact can see what that officer was involved with. I would think the officer would want to do this. It would be helpful to him in this case. Okay, so the violation is interfering with the police officer. We put in an additional requirement at 25 feet. And don't give me this stuff about you don't want somebody to hear what you're talking about. It's private communication. Well, take the person away from the officer can do that. Take them outside of hearing of a third party. So this is just a simple amendment. We've tried in the past to require police officers to keep their body cam on whenever they're in contact with the public. And this amendment is consistent with that. I mean, if we're going to be fair to the average citizen, you know, the average citizen on his property, he ought to at least be able to see a body cam where the officer is saying he's interfering or he's within a certain distance that's prohibited. I think the whole thing is suspect of being unconstitutional, but this would help the bill. It would help our citizens.
Members, I want you to ask yourself, I want you to think about all these videos you've seen, all of these things you thought were either appropriate or inappropriate, things you saw police officers doing, things you saw suspects doing, and ask yourself, what's the outcome of that video if the person complied and stepped back 25 feet? That video looks, in most instances, significantly different. But I'm going to leave you with this before I ask you to support this bill. We've now debated for about 50 minutes, what's going to take an officer 1 second. We judge that officer. We ask him to raise his right hand and swear under oath for what he's going to do for 1 second. And we can't even come to a conclusion in 40 minutes how to make this a safe profession for the officer. I'd ask for your support.
A day before the House bill became law, a coalition of media companies band together and filed a lawsuit. And in it, they referenced Turner versus Driver, and they also referenced another case law that was adopted from the Supreme Court that we heavily used in our Fifth Circuit argument. One of the main complaints of the lawsuit was that the 25 buffer zone would prevent third-party media from efficiently gathering news in an effective manner. Plaintiffs' proposed course of conduct is protected by the First Amendment, the constitutional safeguards the right to gather news, and re-express News Corp, which is the case law that we heavily used in Turner versus Driver, including by capturing images where reporters are lawfully present, see National Press Photographers versus McCall, and by filming police, in particular, Turner v. Driver. An inhibition of press news gathering rights must be necessitated by a compelling governmental interest and narrowly tailored to serve that interest, but criminalizing peaceful, non-obstructive news gathering advances no legitimate government interests. News gathering that does not interfere with police officers' performance of their duties is not reasonably subject to limitation, because the Act's scope is untethered to any of the interests that purportedly justify it, the statute is not narrowly tailored. The judge granted the plaintiff's motion for preliminary injunction, and the court found that House Bill 173 was unconstitutionally void for vagueness in violation of the 14th Amendment. And as a result, the defendants and their agents shall be prohibited from enforcing Louisiana Revised Statute 14-109. Other states are also passing similar 25-foot buffer zone laws when it comes to law enforcement. Indiana and Arizona are two that come off the top of my head, and both states have their laws blocked by federal judges. It'll be interesting to see if other people will follow suit and challenge their state's 25-foot buffer zone law when it comes to law enforcement. Because as we all know, freedom should not come with an asterisk. Let me know what you guys think about this video in the comments below, and I'll catch you in the next one.